All right, we're back on the record on State versus Rosario. Mr. Rosario and his attorneys are present. The State Attorney's Office is present. The court is going to conduct a Richardson hearing on two issues: the issue of the Baker Act document and the issue of the judgment and sentence from the state of Texas. I'm going to start with the Baker Act document. Mr. Whedon, do you have a document indicating that Ms. Gutierrez was Baker Acted?
I saw a police report, Judge, indicated they took her and hospitalized her.
You saw what?
A police report indicated she was taken and hospitalized. I don't have court documents, just so that it was called.
What police report would you have seen? Since Baker Act proceedings are completely confidential and are sealed court documents, do you have it with you?
Well, Your Honor, I may have spoken using the word Baker Act. I should probably not have used that phrase. I used to do mental health hearings, so I know the procedures, and what happens is the law enforcement thinks someone is a danger to themselves or others. They do what's called a 52 form, which is under the Baker Act statute, and they take them to the hospital involuntarily for examination.
The witness denied ever having been Baker Acted. Is this an issue that you intend to revisit in any way, shape, or form? No. Does the state wish this Richardson hearing on this particular issue to go any further?
Judge, I hate to belabor it, but the cumulative effect of these, I do think, need to be recorded. My fear going forward is that there are more documents I don't have. So the answer to that is yes.
All right. So at this time, Mr. Whedon, you're telling me that you do not have a document indicating that Ms. Gutierrez was Baker Acted, even though that is the question you asked her when she was on the stand. Is that correct?
Just the incident report, which reflected the law enforcement to her 52, which is under the Baker Act.
Have you turned that in? First of all, how did you get that incident report?
I sent it to my investigator.
Interesting. Have you turned that incident report over to the state attorney's office?
No, I was not going to, I asked the question, and they could back that up, and if you have good faith basis for asking a question, you asked the question. She denied it, and I didn't go any further.
The question that I asked you is, have you turned that document over to the state attorney's office?
If they don't have, we did not do that thing.
And how long have you had the document in your possession?
In my personal possession, Judge, since Friday.
Mr. Williams?
I think it's willful violation of the rule. What we always end up coming down to with this is prohibitive prejudice to the state. And I do believe the state is prejudiced on this, in this accord. Your Honor sat as I went through significant detail with Ms. Gutierrez and the things that I thought might be potential impeachment evidence. And I did that to, as the case law says, bring out the sting. I obviously did not ask her about mental health. First of all, I don't even know if that's relevant at this point. It's a separate issue of whether there's a good faith basis to even ask the question. But I do believe that the state is prejudiced by not receiving this document because I would have at least brought it to the court's attention or moved in limine to prohibit the question.
I do think it's a willful violation. This is the second one this morning. I do think there is a prejudice to the state because you rang a bell that can't be unrung. I'm not even sure that that document is admissible. I'm not even sure that you can bring this up because of the rules governing mental health records and Baker Act records specifically. They're sealed. The only people who can see them are the judges and obviously the clerks who handle probate. So there's a separate issue with that. The issue now becomes the sanction or the cure for the prejudice to the state. We had moved on from that. Mr. Whedon is indicating he doesn't intend to bring it up again, which probably leaves me with a curative instruction. Which is just going to bring it back up to the jury, but I think the issue is what the state is asking for.
We are not requesting a curative. My recollection of the testimony is that she said no.
She said no. She denied it, which is why I said, is this going to come up again?
Correct. So no, I would not request a curative.
No party may mention the mental health issue since the witness denied it, and there is no document indicating, no admissible document that I've seen, and we have a discovery violation. But you're telling me you did not intend to bring it up again. Is that correct, Mr. Whedon?
Correct.
All right. Next up, we have the judgment and sentence from the state of Texas. Mr. Whedon, when did you obtain the judgment and sentence from the state of Texas?
Judge, again, this is in my case notebook. I just going through this, I did not realize this was a mystery because the state attorney called Texas, talked to the, I didn't even realize.
Mr. Whedon, when did you obtain the document from the state of Texas?
Personally, I had it in my possession as of Friday.
Did you turn that document over? Just answer my questions. This is a Richardson hearing. Did you turn the document over to the state attorney's office when you obtained it?
No, because I believe they knew about this because they knew that she had charges pending in Texas. They called the district attorney out there to confirm that she was a convicted felon. The other day I brought it up to the court. I said, she has because we talked about impeachment, and I said, well, she has a 2-year suspended sentence in Texas. May I bring that up? And he said, certainly. So I didn't realize that this was something the state was unaware of.
Okay. Mr. Williams.
Judge, I did not have the document. Mr. Whedon is correct that I did contact the district attorney in Texas, and the only question I asked was there an adjudication? Because my understanding of the law is that that's the question that is really relevant on this topic. And when I was told that there was an adjudication via email, and I actually received the sentence as well, I forwarded that email to Mr. Whedon and to Mr. Davila, I believe on Friday.
I got the copy of the email.
Yeah. So I did not have the document.
What is the prejudice to the state? Because I will say this, there was a discussion of the fact that she had a 2-year suspended sentence and that I would allow the state or the defense to inquire into that. So what is the prejudice to the state?
At this point, I do not believe there is any. My issue is using that document any further or showing it to the witness to elicit any further testimony beyond what has already been done. Because obviously, had I had details, I would have gone through them with the witness. Leaving aside the separate issue for a moment, that I don't think that that's relevant or proper where we are. As far as the Richardson hearing goes, the prejudice the state has is that I didn't have the document or the details of the adjudication because I didn't think it would be relevant, beyond the fact that she was adjudicated a felony.
But we did speak about the fact that she had a 2 year prison sentence, and I would expect that when that was put out there, they would explore that and confirm it, and then they could talk to her about that.
While this is a discovery violation, third one, while this seems to be more of a confusion and less deliberate on Mr. Whedon's part, the fact is the state doesn't have any prejudice at this point in terms of the document itself. I did indicate that I would allow them to ask questions. I would allow the state or the defense to ask questions about the suspended sentence. It goes to the issue of whether she's getting any benefit for her testimony, which is why the court would allow it. Hold on. I believe that the witness needs to be shown the document before she retakes the stand, because had the state had this document in their possession, they would have gone over the document with her and had the opportunity to talk to her about that testimony. She needs to be shown the document and given the opportunity to correct her answer after having been shown the document. I didn't read the whole thing, but it does appear that the document itself is rather confusing. The sentence is 2 years in the Department of, what I would call the Department of Corrections. They call it something else. But below it in much smaller type, it says suspended upon something, and I don't remember what else it says. The document's a little bit confusing, and I believe she needs to be given the opportunity to go through the document exactly as if the discovery violation had not occurred.
And that's prejudice, because she's already said no. She was asked the question if she has a suspended sentence, and she said no. And now defense counsel wants to use the document that he withheld from us to impeach her with. And we're asking that the court strike that document and not permit him to do that.
And to allow a false statement to be perpetuated?
Mr. Whedon, just give me a minute, okay? I don't like this back and forth. I'll let you all know when I need to hear from you. I understand what you're saying, Mr. Williams. However, I don't know that her statement was false in so much as she's not the first defendant who's been unable to tell a court what their correct sentence is. I think that she can be re-asked the question, do you have a suspended sentence in the state of Texas, without any further comment. After reviewing the document, her answer is her answer. If she says no, then the defense would be able to use the document. But this is the one exception I'm going to make to a witness not being able to look or see anything when they're on the stand, which is that I'm going to allow her to look at the document and review the document before she retakes the stand. I will allow the question to be re-asked in a neutral fashion. You cannot say, you just told me no, have you reviewed the document? You just need to ask it as if we're starting from the beginning, which would have been what would have happened had the discovery violation not occurred. I can't think of anything else that I can do to fix the issue at this point.
The thing to do is to not permit the impeachment. That's the whole issue right now. Because she has given an answer, and now she is going to have to acknowledge that that answer was wrong. Whether she acknowledges it or gets impeached by it, the jury it has the same effect for the jury. And I agree, I cannot think of a way that Your Honor can tell the court that the witness was confused, because I think that's probably what it was. And it's certainly a confusion that I would have clarified with her had I had this document that was withheld from me. I understand the defense counsel's position that technically her answer is incorrect. I understand that. But that doesn't change the fact that we have now been ambushed for the third time in 2 days.
I would like to talk, Judge.
Yeah, let him finish and then you can talk.
So, for the record, Your Honor, the state does not believe it to be a sufficient remedy to allow the witness to review the document because it does not change her answer and the impression the jury will be left with that she is changing her answer. From the very beginning of this trial, we have talked about the fact that this witness's credibility in other contexts is the key. And now defense counsel is getting a benefit from his wrong, so to speak. So that is the state's request that the court not permit that document to be used for impeachment.
Mr. Whedon, you may respond.
As Your Honor indicated, we spoke about this a couple of days ago, that the fact that she had a 2-year suspended sentence, so no one's been ambushed. Plus, the state has a duty to really explore the background of their witnesses, especially when this is essentially one witness case. They claim they'd been ambushed when they were told at least a couple of days ago that she has a 2-year suspended sentence. He's in contact with the prosecutor over there, and his due diligence should have discovered all this to begin with, but there's been no ambush yet, because this has been out there for a couple of days.
In case anyone has any doubts, I am not happy this morning about the continued discovery violations by the defense. I have repeatedly told you, Mr. Whedon, to turn things over to the state. The first time you answered me by telling me I didn't have any jurisdiction because this was in front of the Supreme Court, and I warned you then about consequences for violating discovery rules. After the mandate issued, when it was clear I had jurisdiction, I issued a written order directing you to turn over all evidence by a certain deadline. To the best of my recollection, you failed to meet that deadline. You now have violated the discovery rules in this trial 3 times. Not an hour ago, you assured me that there were no further documents, issues, or anything else that you intended to use for any purpose or evidence that you had not turned over to the state, and in less than an hour, you violated that twice. There's a limit to the amount of patience that I have, and everyone is bound by the discovery rules. The fact that this is a death penalty case does not void the discovery rules in this case. Is there any part of what I just said that you do not understand, Mr. Whedon?
Your Honor.
Just answer my question. Yes or no? Do you understand what I am telling you, Mr. Whedon?
Just a yes or no, Judge. I think is.
Do you understand that you are bound by the discovery rules?
And I told you
Right.
that I thought they had this document, Judge.
You have told me that about each and every document, Mr. Whedon, and at this point, quite frankly, I have some question about whether you are telling me that in good faith or not. We are going to move on. Do not interrupt me. Sit down, Mr. Whedon. You're not in a good position with me right now. I'm going to keep in mind that this is, in the end, about Mr. Rosario. I am going to allow Ms. Gutierrez to review this document and change her answer if she chooses to change her answer. I will forbid anyone from commenting on the fact that she changed her answer because of the discovery violation. If she changes it, if she continues to say she doesn't have a suspended sentence, then at that point the document comes in. However, one more time, Mr. Whedon, do you have anything else that you intend to use in this case because you need to turn it over in the next 5 minutes? Because after this, it is unlikely that Richardson hearings are going to result in anything being admissible. I will conduct a Richardson hearing and determine the amount of the prejudice. but I'm not going to continue to allow discovery violations by either party. Although at this point, the state hasn't violated discovery. Anything else you want to turn over, Mr. Whedon?
No.
All right. Mr. Williams, you may take the document and show it to the witness. Tell me when she's had time to review it and when she's ready to take the stand again.
Yes, ma'am. just dawned on me that you might be waiting on me. The witness is ready. Sorry.
Where's the document?
Mr. Wheaton has it.
He has it back. All
Do you
right.
want her to come in and sit down, or?
We're now going to have a timing issue. It's 20 to 12. Mr. Whedon, how much longer do you believe your cross is going to be?
Probably 45 minutes.
So if we went till 12:30, you could finish your cross of this witness?
I can't promise.
All right. Let's see how far we get. I'm not willing to go much beyond 12:30. If you're 5 or 10 minutes away from finishing, we'll finish, and then we'll just take a late lunch. And I'll bring the jury back. You have more witnesses to call this afternoon. Is that correct?
We do have more witnesses, yes.
Okay. All right, let's put Ms. Gutierrez back on the stand, and when she's back on the stand, we need to bring the jury back in again. I'll explain the schedule to them. All right, Ms. Gutierrez, just remember that you're still under oath.
Yes, ma'am.
Let's bring the jury back in, please. Stay recognized, please, to the jury.
Yes, Your Honor.
Defense?
Yes, Your Honor.
All right, welcome back, folks. We're going to work until about 12:30 before we take a lunch break. All right, since we had to take a couple of breaks this morning. All right, thank you. You may proceed, Mr. Weir.
Thank you, Your Honor. Ma'am, so you testified you're on probation in Texas, correct?
Correct.
For 4 years?
Correct.
Okay. And you also have a 2-year suspended jail sentence, correct?
After going over the document, I realized it was suspended.
So if you violate your probation, then you could end up in jail for 2 years, correct?
Correct.
Now, you indicated that Mr. Rosario asked you for some money early in the evening on September 13th, or September 18th, correct?
Correct.
And you would have had money by midnight, right?
A little after midnight.
And that could have come off of a debit card?
Correct.
So you could have given him some money after midnight?
Correct.
Or you could have loaned him your debit card?
Correct.
Right. Now, so you say, did he wake you up or did your alarm wake you up?
He woke me up before my alarm went off.
And is it your testimony today that he just had some specks of blood on him?
Like, he had spots of blood.
Didn't you previously tell Detective Thorpe that he was covered?
Objection, improper impeachment.
Sustained. Rephrase.
Did you ever previously testify that he was covered in blood?
Objection, improper impeachment.
Sustained. Rephrase.
Did you ever see him covered in blood?
I just remember him having blood on him, not that he was covered.
Did you ever tell anyone that he was covered in blood?
I don't recall.
Approach the witness, Judge.
You may.
You recall him the deposition, excuse me, you recalled your interview with Detective Thorpe back in June of 2017, correct?
Correct.
Agent line counsel.
I'm looking at page 2, line 26.
I recall.
Does that refresh your memory?
Yes.
So, in fact, you told he was covered with blood?
Correct.
Is that correct?
Correct.
Now, with your testimony today, it was just specks of blood?
Yes, like splatters, not specks.
When what did you see Juan Rosario have when you woke up?
He had 3 suitcases.
3 suitcases?
Yes.
And how big were these suitcases?
They were regular size. One was probably large and a medium size. There was 3 of them.
Can you demonstrate with your hands how big they were?
Probably about this big. And then another one was like this big, but I'm not exactly sure about the third one.
And these 3 suitcases, where were they?
They were in our bedroom.
Or were they open or closed?
He had already opened them.
Were the contents in this, were there still contents in the suitcases?
Yes.
Did you empty out those suitcases?
We were going through them.
Since your testimony that Mr. Rosario did these things on the 18th by himself,
Yes.
he didn't have any transportation back then, did he?
No.
In fact, he had to get around on a bicycle.
Yes.
Did he have anything else with him?
Just the makeup bag that I remember.
So 3 suitcases and a makeup bag?
Yes.
Now, is it your testimony today that he said he had to go back and kill the woman because she saw his face?
Correct.
Did you ever tell him about here that he never specifically said he intended to kill her?
No.
You recall testifying back in March 2016?
Yes, yes I do.
You recall testifying that you never said that?
Objection, improper impeachment.
Sustained. Rephrase.
You recall what your testimony was back then about whether he intended specifically, did he ever said he intended to kill her or not?
Yes, I remember.
What was your testimony?
He said he had to kill her because she seen his face.
Isn't it true that back in March 2016 you testified you didn't?
Objection, improper impeachment.
Sustained. Rephrase.
Have a second, Judge?
Yes, sir.
Back in March 2016, you were placed under oath, correct?
Correct.
To testify in this matter?
Yes.
All right. And you recall being asked questions by Mr. Jonathan Rose?
Yes.
And I'm looking at page 625 for the state. You recall Jonathan Rose saying to you, didn't he tell you that when he was in your house?
Objection, improper impeachment.
Let me see the attorneys at the bench, please. the best laid plans of mice and men. We're going to need to take a witness out of order. This is not uncommon in cases that go for a few days. So I'm going to have Ms. Gutierrez step off the stand. Still under oath, still on the stand.
Yes, ma'am.
Rules. We're going to take this witness out of order, and then I've had an issue that's popped up that requires my attention. Each of the judges carries a lot of cases, so it's not always, and we have some legal issues to discuss. So the good news for you is we're going to take this one witness, and then we're going to recess until 2:30, but we're still going to finish this case on time, even though it might not feel like it. All right? So, step down, Ms. Gutierrez. All right, call your next witness.
Thank you, Your Honor. State calls Edgar Concepcion.
Edgar Concepcion?
The testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Please report.
May inquire.
Thank you. Good afternoon, sir.
Good afternoon.
Could you please tell us your name and spell your last name for the court reporter?
Edgar Concepcion, Concepcion.
What is it that you do for a living, sir?
I'm currently retired.
Congratulations.
Thanks.
At some point in your life, did you own 7-Elevens?
I do. I have a franchise, yes.
You have a franchise.
Mhm.
I want to speak to you about your capacity as the owner of a 7-Eleven. Did you have an employee by the name of Janet Gutierrez?
Yes, I did.
And do you recall her working for you in September of 2013?
Yes, I do.
At some point in September of 2013, did she request a ride to work from you?
Yes.
Do you recall approximately what time of day that was?
Typically, I picked her up somewhere between 5 to 5:30 a.m. in the morning.
On one of the times that you picked her up, did she have something with her that caught your attention?
Yes, she did.
And what was it that she had in her possession that caught your attention?
Some trash bags.
And did she get into your vehicle with those trash bags?
Well, first she asked me if she can bring them to work, and I said yes, she could.
Okay.
So,
And after permission, she brought them into your car?
yes, she did.
And when you arrived at 7-Eleven, what did you observe her do with those trash bags?
She basically just took them out of the car and walked towards the dumpster.
Okay. And is that the last that you saw of those trash bags on that day?
Yes.
Thank you, sir. At this time, I have no further questions.
Cross. Mr. Davila?
Yes, ma'am. Good afternoon, Senor Concepcion.
Good afternoon.
I'll be brief. You were the employer of Janet Gutierrez, correct?
Yes, I was.
On a certain date, you picked her up in the morning, correct?
Yes, I did.
That day, she came with some trash bags?
Yes, she did.
Was that unusual?
Very unusual, yes.
Did you notice anything about those trash bags?
Not at all, not really.
Were they the white kind or the black big kind?
I believe they were white.
You didn't see any liquids coming out or on the sides or anything of that nature?
No, sir, I really didn't pay attention to, it was of no consequence, it was just trash bags, so.
So you had no idea what was in there?
No, I didn't.
You never asked her?
No,
And she never volunteered, correct?
no.
Thank you, sir.
Thank you, Mr. Davila. Redirect?
None, Your Honor?
May this witness be excused.
Yes, ma'am.
Sir, you're released. Thank you very much. You're free to go. Enjoy
Thank
your
you.
retirement.
Thanks.
All right, folks. So we're going to take a regular lunch break at noon, and like I said, it's extended. Please don't look at anything during on the lunch break. Don't look at the news or read anything in the news. Have a great lunch break. We'll start back at 2:30 with the trial so we can get everything resolved before you guys come back in again. All right, thank you. Anything else we need to discuss before we take a lunch break?
No, Your Honor.
Are you?
Yes, Your Honor. Your Honor, it's my belief that, Mr. King, correct me if I'm wrong, that the travel time recording is on the flash drive that I'm handing to Mr. Lee right now.
All right, great. Thank you very much for arranging that, Mr.
So, Mr. Weed understands there's 3 files.
Okay,
One file, the battery died in the midst of re-recording it. So the one conversation, which was like 26 minutes, is on what is on that flash drive as Gutierrez 2 and 3. The one designated Gutierrez, Texas, is about an hour and 26 minutes of the drive from whatever facility it was to the airport.
all right, thank you. Hold on one second. Just advise the jury room that they can restamp the whole thing for the jurors, please. All right, anything else we need to discuss? Mr. Whedon, you've got the flash drive, so that should give you time to go get some food, listen to it. I'll see everybody back here. Try to get back about 2:15 or so, in case there's any issues, we can discuss it at that time.
Yes, Your Honor.
All right, thank you all very much. Court's in recess. Yes, ma'am.
You have a room we can use?
All right, reinstate his bonds? Yeah. Yeah, sure.